Several significant legal issues were addressed when the Supreme Court of Ohio conducted oral arguments in March 2026. The court heard 4 cases, including the right of doctors to prescribe puberty-blocking medications to minors and a prosecutor's right to appeal a judge's decision to reduce a suspect's criminal charges. State lawmakers enacted House Bill 68 in 2023. Part of the legislation prevents prescribing puberty-blocking medications or sex hormones for the purpose of gender transitions for those under 18. 2 families with children diagnosed with gender dysphoria asked the Franklin County Common Pleas Court to block the law from taking effect. The trial court declined, and the families appealed to the 10th District Court of Appeals. The 10th District found the new law unconstitutional. It prevented the law from taking effect. The Ohio Attorney General's office appealed to the Supreme Court. The justices questioned whether state lawmakers could determine whether the procedure constitutes health care.
Is it the state's position that parents have no rights in this?
That's not exactly right, Your Honor. Our position is that parents do not have an unlimited right to override the General Assembly's contrary determination. It's not a constitutional right.
Court not find this as health care?
Well, Your Honor, legally, it is not health care, but medically, some may consider it health care. As long as the General Assembly makes a determination that a particular procedure, here gender reassignment treatments are unavailable, that does not constitute legally allowable health care in Ohio.
The families argued that under the Ohio voter-approved Health Care Freedom Amendment, lawmakers cannot restrict procedures deemed as medical treatment. The justices questioned whether the legislature has some power to restrict medical care.
Clearly, there's all kinds of what someone might define as health care that the state can ban parents from seeking for the children and ban from seeking for themselves. So,
under strict scrutiny, the question is, does the state have a compelling interest, and then is the law narrowly tailored? We are not disputing that the state has a compelling interest here. This law is not narrowly tailored to meet that interest. And I think the state's interpretation that the General Assembly can define something out of the HCFA by defining it not as health care entirely guts this unique Ohio provision that preserves these rights.
In a second case, the court considered an appeal from the Muskingum County Prosecutor's Office. The prosecutor indicted Scott Burrell in 2024 on 1 count of third-degree domestic violence. It was a third-degree charge rather than a lower fourth degree because Burrell had 2 earlier domestic violence convictions. The trial judge lowered the charge Burrell faced to a fourth-degree felony. The trial judge found a 2011 conviction could not be used to enhance the punishment for the new charges he faces. The prosecutor's office sought to appeal the judge's decision before proceeding with the case, arguing it had the right to seek the higher third-degree crime. The 5th District Court of Appeals ruled the prosecutor doesn't have an automatic right to appeal the trial judge's decision, but must request permission from the appeals court to appeal the lowering of a charge. The prosecutor appealed to the Supreme Court, arguing that under state law, it had an automatic right to challenge and explain why the charge should not be lowered. The justices questioned the prosecutor's authority.
Why do you need this broadened right to appeal?
Yes.
Why?
The state needs it because anytime the indictment language, which kind of sets the universe of justice that can be done and what convictions can be sought, when the court starts deleting language from the indictment, it radically changes the work of the grand jury. So this broad right of appeal prevents any type of mischief or wrong court actions that may happen when the language of the indictment starts getting deleted.
Burrell's attorney argued the prosecutor has to follow the same rules as criminal defendants, and in some instances needs permission from the appeals court to file an appeal.
We're here because the state doesn't want to have to file an inconvenient motion for leave. A motion for leave is a fairly common thing to do when you're a litigator. I've pointed out several times when a defendant needs to file a motion for leave on even what I would argue would be even more serious issues, but the state doesn't want to do that.
I'm trying to imagine when the trial court discovered that there was a prior uncounseled domestic violence conviction, what differently could it have done than what it did?
I don't think anything. I mean, they had the hearing. They brought in the judge who presided over the case, who is now retired. I mean, this is 10 years ago, something like that. It held a proper hearing, and it came to the conclusion that the plea was not counseled.
Chief Justice Sharon L. Kennedy announced the court will take the arguments under advisement and inform the parties of its decisions. You can follow these and other cases before the court by visiting our website at supremecourt.ohio.gov and signing up for case activity notifications. The court meets for oral arguments at the Moyer Judicial Center in Columbus. Each session begins at 9 a.m. You can also see them live online at supremecourt.ohio.gov.